We're not just actors.
We're not just trial consultants.
We've been cross-examined over 1,500 times in cross simulations to help train and coach some of the world's top trial attorneys.
Through live witness sparring, we'll test constructive cross techniques, share fresh insights, and explore new strategies.
And even though the testimony may be fake, the trial skills are totally real.
So let's experiment, discover what works, and have some fun in CrossLab. This show is brought to you by Trial House Consulting and powered by LawPods. Welcome to CrossLab. I'm Steve Hohman.
And I'm Olivia Espinosa.
First off, we need to be honest. We're not lawyers, and we're not going to talk about the law.
Nope. Specifically, we are focused on storytelling and how you make your witness and jury feel through what has been famously called constructive cross.
We call it a yes and cross. Basically, it's the strategy of making the opposing witness a tool to tell your case narrative.
And if you've ever watched or listened to CrossLab before, you know that we design a test case that sparks ideas, word choice, and questions that you can use for your next deposition or trial. Steve and I, in past episodes, also simulate the cross-examination witnesses.
But for this episode, we've got a guest mock witness who will be sparring against our attorney. So let's introduce them and get started.
Okay, joining us today, we have Susie Injijian. She is here for a second time in the Cross Lab. She's an award-winning trial attorney based in Berkeley in the San Francisco Bay Area, representing plaintiffs exclusively in personal injury and wrongful death cases. You might have recently seen her on TLU's Case Analysis, discussing her case that led to a huge $25.5 million verdict. Welcome, Susie.
Thank you. It's great to be here.
So happy to have you back. We also have Sara Taylor is here as our guest performer to play the part of our defendant in today's test case. Sara is an actor, a writer, and a stage manager based in Los Angeles. She's an acting graduate from Emerson College, and she loves all aspects of storytelling and has actually been helping us in our Cross Club classes recently, offering really great insight to our participants. We're so happy to have you here, Sara.
Happy to be here. Thanks for having me.
Well, welcome, Susie and Sara. Before we jump into our mock case, we want to actually have a discussion about what this case is kind of about today.
Yeah, so this mock case we're tackling today involves a plaintiff who is an immigrant male and a defendant who is a young white female. So in this case, there could be multiple biases that could be a factor. And so before we jump into that cross, we want to just have a conversation about facing that head on, things that might come up, and building a strategy that can give your client the best chance to be seen and their story to be told clearly.
And in general, what to do when you're asking for real damages against a sympathetic defendant.
So Susie, you just did a big trial in the Bay Area, a blue-collar worker. And did you find that bias played a role in any way in that particular trial?
Well, I think it's always there, and you have to deal with it right away in jury selection. So the voir dire is really crafted to elicit any expressions of bias in your potential jurors, and to make sure that any who are likely to sort of discount the damages of your client because of his ethnicity or demographic place in society, that those people are not on your jury. And Alameda County is a pretty good place for that. We have a diverse population and an increasingly a technologically savvy population. We have Silicon Valley nearby, and people who work there and in San Francisco really love to live in the East Bay. In Berkeley, where I am, and in other towns in the East Bay, it's just for lifestyle, it's great. So we had a lot of intelligent people on our jury, and it wasn't as big a problem in this case as it would be in many other venues in the state or in the country.
You know, when you're talking about, obviously, the geography of where you were, it makes me want to ask you, how drastically does your geographic location of a trial influence your expectations for a personal injury verdict?
Well, it does. I mean, you basically have to decide when you file your complaint what jurisdiction you want to be in. And as a plaintiff's attorney, if you have a choice, then you're going to do that analysis, and you're going to pick the jurisdiction where you think the jury pool is going to be more favorable to plaintiffs. And sometimes there's a fight about that, where the defense will, if they can, put you in federal court. And if they do that, then you've got the federal court jury being pulled from various counties within the district. So if it's the Northern District of California, you don't just get the East Bay, you also get San Francisco, you get some conservative counties that are also included in that district. So that's one example. And then another example is when the plaintiff picks a favorable forum, and then the defense comes in and says, no, we belong in this other court where there are more conservative jurors. In fact, I experienced that in an aviation case many years ago when McDonnell Douglas was based in St. Louis. And apparently there is one half of St. Louis is very working class, and the other half is upper class and more affluent. And we had filed in the working class, and there was a big fight with all these aviation defense lawyers, a whole mob of them, trying to get us in the other part of St. Louis. And not knowing anything about St. Louis, I walked into that and had to make the argument to the court that we had filed in the correct county, or part of, I guess the county was divided. I still don't know how that worked, but that's how important it is to be in a plaintiff-friendly county.
Wow. So how did that end up working out for you?
We won. It was especially fun because I was just by myself, and I basically had to, ice skate to court, which I'm not. I'm a Californian, and I don't know. There I was in my pumps, and there were all these defense lawyers in the courtroom, and the judge, listened to me, and so we prevailed, and that's why I remember it so well, because it was a fun appearance.
Yes. Wow. I forgot. I mean, I was actually gonna, when I introduced you, I forgot to say, you're a badass. You really, really are. When I think of badass lawyer, I think of you because of just and you even said it in this particular case that you were talking about, in that jurisdiction, you are up against multiple people. And then in fact, with the recent case, in Berkeley, you were up against multiple corporations, right?
Yeah. Well, there were 3 defense firms against me. And I did the whole case myself, except for a very brief time. I had recruited a friend to co-counsel with me, but then she couldn't do the trial. And so I brought my son in to do the trial. And he was recently out of law school, but he was a great asset. And nobody knew we were related. So that was also fun.
Yeah. We actually, on our last Cross Lab episode, we did an episode where we had a couple father-son teams, and they talked about what it's like to do that too. So yes, absolutely. So when we go back to sort of that conversation about your jury members, how do you approach that to kind of get those biases or potential biases out? How do you kind of broach those subjects?
Well, there's kind of 2 things. The one has to do with the ethnicity. And that's a tough one. I mean, I know that some people will get up there and they will talk about how we all harbor biases. You're not really going to get anybody to admit to being biased against Latin Americans or against people of color or women even. You're not going to get them to say that. So you really have to do your homework in terms of focus groups and get an idea of what interests people are going to talk about if they are less likely to be biased, and what they're going to talk about if they are more likely to be biased against your plaintiff. So it's become very refined. We do a lot of data studying before we go to trial. So you come in with that knowledge, and you ask your questions accordingly. The other big bias is against lawyers asking for big numbers, and asking for big numbers for people who earn a minimum wage or who aren't really rich. And there's some voir dire, some jury selection lines of questioning where you can ask people, do you think that Bill Gates' life is worth more than the guy who does your garden? And so we can ask questions like that and get a lot of information, and also sort of let the jury understand that, hey, if they really think that Bill Gates' life is worth more, or someone else who's really rich, it makes them wonder, well, what is that based on, and is that fair? So it's kind of a nice process.
Do you find that even with all that research that there, you know, and it goes into what you're saying about, is Bill Gates' life more important than your landscaper or, you know, somebody doing a minimum wage job? Do you find that in our just overall, when you're working with juries in any case, that there is a bit of a bias against blue collar or working class people versus a white collar profession, people with white collar professions? Is that something that you have to fight against?
Well, I think because there is the money grab bias, there is that thought that, and this was really sort of promoted by so-called tort reform in the 80s and the 90s. We heard a lot more about it then. It's more subtle now, but the idea is that personal injury lawsuits are a money grab, and they are people trying to get something for nothing, trying to get rich off of their misfortune, faking, exaggerating, because here's their chance. So if you have a blue collar worker, someone who has struggled financially, then, there's that motive, right? It's sort of promoted by the defense that motive exists more prominently in someone like that than in somebody who is really wealthy.
I was just going to say, it kind of rolls into that idea of thinking about blue collar people having more personal responsibility or less deserving because of where they are in earnings, versus a white collar person and their level of deservingness or personal responsibility that plays into the juror's mind.
Well, I think you're right. And I also think that these biases can exist in people of all walks of life. So you can have these biases among blue collar workers. In fact, it's quite common where you have, in my recent trial, we had a self-employed electrician who was injured on a job. His hands were on the tools when they exploded. And so a big bias that we had to overcome was, well, he was the only electrician there, and it must have been his fault, or some aspect of this must have been his fault. And in our jury research, we learned that self-employed people who were just scraping by with their businesses were most critical of him. And part of that is because they don't want to believe that this could ever happen to them. They believe that they're always safe and they take all the right precautions. And so if he got injured, he mustn't have been taking all the right precautions. And yet there were people who were working in big corporations earning sizable salaries, and their jury service was being paid for, or they weren't losing any money serving on the jury. They were more sympathetic because they were used to the idea that there are organizational divisions that take care of safety, and they rely on that, and they believe that people should be able to rely on that. So those people ended up actually being better for us as jurors than people who were in the same, socioeconomic status as my client.
We actually got to work with you a little bit on the prep for that case. And I remember when you first discussed that case with us, and it was in a group setting, and we heard the basic facts of the case. I remember going, oh God, this is a really tough case. I don't know, how Susie's going to get, to where she wants to go. And I remember it was that same bias in me of that personal responsibility that's been drilled into us. And you mentioned it before, it's the hot coffee and the lap thing from the 80s that's been drilled into us systematically for the last 3 decades about personal responsibility. And like you said, the money grab. So I was even thinking about where we were at that moment until we learned more about the case, and my thoughts evolved on it very quickly. And I understood where we're going to go with that case. But it's amazing how you can even recognize those biases in yourself, even when you're open-minded and I was in service of you, of course. So it's just interesting I don't know if there was a question, but I just find it interesting that on even thinking about the way I thought about that case in the beginning to where I evolved to, it's I think indicative of our society in America.
Well, you make a very good point. In fact, there are lawyers who, when they're given the latitude in jury selection in voir dire, they will actually be a little bit confessional like that, and talk about how, well, when this case first came to me, these are the biases that I surprised myself that I had them, that I entertained these thoughts. And it was only when I saw the facts that I overcame them. Now, you're not allowed to do that in jury selection, but, we push the envelope where we can. And I've never seen it done, but I've heard from lawyers who have done this, and they do it in order to get the jury members to feel comfortable to fess up themselves to their own biases and to get that dialogue going. And it can be very effective. But you're right. We all have biases. And that's one thing that we try in various ways to communicate to the jury during voir dire to make them feel comfortable to own up to theirs. And then we're able to say to them, well, so does this mean that maybe another case would be better for you, that you couldn't be entirely impartial in deciding this case? Yeah. And that's okay if that's true. And if he says, yeah, I can't be entirely impartial, then under the code, he must be dismissed for cause, he or she, or they.
What about in terms of biases, even potentially with, injuries that are more visible or invisible and subjective, like pain or trauma, MTBIs, especially when those injuries, don't come with maybe dramatic imaging or overt symptoms. Have you ever tried a case with that, or how would you approach that particular biases?
Yeah, juries are very interested in evidence and documentary evidence. And so it's always better to have radiographic imaging, medical imaging, particularly the type that is widely accepted. That's the gold standard, CTs, MRIs. There's lots of other types of imaging available now that plaintiffs' lawyers are using, but they're also under attack by defendant doctors who say, oh, that's just experimental and it's not dispositive, and so forth. So it is always better to get the documentation. But bottom line, you really need to tell a story, whether the images, the damages are visible or not. You need to tell a story of before and after. And you do that through your client and through their treating physicians. Ideally, they're going to be very supportive and also good at testifying and explaining the medicine. But you most importantly do it through other people, so what we call before and after witnesses. Mm-hmm. And it could be family members, and even better if they are people. I've heard of, people bringing in the Starbucks barista who saw the plaintiff every morning until the accident and then was able to testify to the change that he or she saw in them.
I want to go back to discussing the idea of deservingness, because I think there is a place to that. I don't think it's all like just a bad thing, because it can help shape your story as well when you're thinking about your client, your plaintiff, and their journey with this, whatever the terrible incident was. I think there's a place of showing that they are deserving this. And I think if you ignore that, that seems like it would be a detriment as well. Susie, how do you go about thinking about your clients, not just the before and after, but thinking of them? And, we talk, you hear this all the time about the hero's journey. It's been very popular, but geez, any superhero movie, any big blockbuster, it has the hero's journey. It's ingrained in us. But how do you go about making it so your client gets over that deservingness question, and you can win over the jury on that matter?
That's such a great question. And thank you for bringing up the hero's journey, because You talked about it in some of the workshops that we did together when I was working up this particular case. And I think about it now with every plaintiff. What is my client's journey that will inspire my jury to want to join and support? And so that's really where the inspiration for the award comes from. And, it's going to be different in every case. Sometimes it's just going to be as simple as your client did not deserve to have this happen to them, and that it's a tremendous injustice. And so what you inspire the jury to do is to support your client through, in a supplementary way, because you present your client as somebody who has really worked hard to overcome this terrible misfortune that was so needlessly thrust upon him, her, or them. So it could be that simple. In our case, we were very fortunate to have a real hero. I mean, this man had a rough upbringing. He was a single. He grew up in a home of single mom. He was the eldest boy. He assumed the role of dad to his younger siblings. He was, and they lived in the projects in San Francisco. And his, the best witness we had was someone he met through Big Brothers of America. And this man knew him when he was 13. This man had just come back from fighting in Vietnam, had just graduated from law school. They had been friends for 50 years. And as he put it, brothers. And so through this man, who was incredibly eloquent, I was able to really tell the jury about my client's hero's journey, and where he had reached, this hardworking person with a really noble calling to be an electrician, to support his family, and to provide illumination to people. And it was what a great service. And this man was able to really bring that whole story out. So we were lucky. But I believe that story exists with everyone. And if it doesn't with a plaintiff, that's a case you want to, think about whether you want to bring it in front of a jury.
I'm so glad that you said that. Yeah, I think that's, what is it that there's also that idea that something has to prompt you to like them, right? Even when we're playing villains, we don't always want to necessarily identify with the villain, but we have to find something in them that makes it worthwhile to play, worthwhile to create a three-dimensional character, someone that also potentially can have some empathy, because that is what makes, a full character that we want to continue to watch.
Yeah, and if you really prepare your client to testify so that their real humanity comes to the fore, you're going to inspire the jury to want to compensate them. Mm-hmm. So lawyer has a role in that too.
Yeah, it's like giving them the jury the fuel to fight for your client, to take action for them. It's you got to inspire them, and that the way that, first of all, Mr. Perez is a fighter. He was a fighter. And so that helped so much in that particular case. But I love what you said, Susie. Almost every plaintiff out there has that own version of it. It might be a slightly different or smaller or little smaller acts that they do to try and live and overcome their circumstances. But you got to find it out. You got to be curious about your client. It just seems like, if I like what you said, if you can't connect with that client in that way, or find that fight in them, it might be it might not be them. It might be the lawyer's vision of that client. But if you can't find that, then that's a big problem, because then you won't be inspired to fight for them. And if you can't be inspired to fight for them, how do you expect a jury to be inspired to fight for them? Today's case is a plaintiff personal injury case, which is Susie's primary area of focus in her practice.
And since Cross Lab is all about getting fresh points of view, we are so excited to hear Sara's thoughts on the cross-examination as well.
So let's get into the breakdown of today's test case.
This is Lopez versus Maddison. The case takes place in Bakersfield, California, a jurisdiction known for its more conservative jury pools. The plaintiff, Gustavo Lopez, is a 43-year-old Guatemalan-born carpenter and father of 5. He was struck by a vehicle while walking his dog near a shopping center. The defendant, Hannah Maddison, a local kindergarten teacher and daughter of a well-known pastor in the area, turned into the parking lot entrance and collided with Gustavo. Gustavo suffered a head laceration, shoulder injury, and later received a diagnosis of a mild traumatic brain injury. The defense initially denied liability but accepted full fault 2 days before trial. Voir dire was limited by the judge, restricting attorneys' ability to thoroughly screen the jurors for potential bias. The jury consists of 4 Caucasian men, 4 Caucasian women, 1 Asian man, 2 Hispanic women, and 1 Hispanic man. The jury was instructed not to consider how any damages would be paid.
Susie is representing Mr. Lopez and will conduct a cross-examination of Hannah Maddison, played by Sara, with the goal of minimizing the impact of potential jury bias on the verdict and damages award. But before we dive into the cross-examination, let's take a quick break. And we want to talk about, really quickly, our partners at Lawpods. Lawyers think that Lawpods are just the company that produces the TLU and Trial Lawyer Nation's podcasts, but actually they create a lot of podcasts with lawyers just like you to help reach non-lawyers, aka your potential clients.
That's right. Podcasts let your audience get to know and trust you. And Robert Ingalls and his team make podcasting easy.
With over 100 million people expected to listen to podcasts this year, there's never been a better time to get this as a tool for getting your practice out there to the public.
And to get more info, visit Lawpods, LAWPODS.com. Tell them we sent you. We want to tell you about what we do at Trial House. We help attorneys in private sessions and in coaching to help you be a better advocate for your client.
We can help you in so many different ways, from learning new trial skills or cross-examination skills to your opening statements, and even working with your clients to be great advocates for themselves in depositions or in cross-examinations in trial.
The best way to reach out to us is to go to our website, trialhouse.com. That's HAUS, trialhouse.com. And we've got 2 free resources for attorneys on there. One to help you craft a compelling narrative for your jury, and another to help you get storytelling gold from your witnesses that's going to help you put a wonderful case together. And you can schedule a 30-minute storytelling consultation with us.
And no strings attached, no pressure. We just want to meet you. We want to talk with you and learn more about your practice and a case that's coming up. You might actually get some really good advice at the very, very least. Once again, trialhouse.com, HAUS. We hope to talk to you soon. Welcome back. We're about to get into this test case. And Susie, just to let you know, I crafted this so you had to deal with bias. That is something that I made sure that you had no choice but to deal with this jury bias. So I'm excited. But Olivia, give us the ground rules.
So we are going to do about 15 minutes today. If it's getting juicy, we might let you go a little bit longer since it's just you. But in the interest of time, you can confirm any potential admissions that you might have already covered with this witness. So Susie, is there anything you want us to know ahead of time?
The only thing I would say is that when we get these fact patterns, there may be little gaps in really fine pieces of evidence. And when we do the constructive cross, we want to make sure that we are speaking in specifics. So I may throw out some specifics that Sara hasn't seen in the fact pattern, and she can respond any way she wants. She can say, she can admit that that's what she said, or that was the case, or she can tell me that, I'm all wet, and I'll just handle it.
Awesome. Yes, we would definitely. And I think that's great too, because that's how we do it in like Cross Club and any of the other programs that we do. We purposely don't give you all the information as the attorney because yeah, there are potentially some specifics, but there's also maybe some angles that you might not have realized that you can take when you can be a little bit more creative with some of those facts.
Sara, without giving anything away about how you're going to be playing the witness, what stood out to you about this character?
I think more than anything, I thought a lot about the way that I could connect to her, which is through the fact that she is young. She has likely never been in a courtroom or on a witness stand before, which I have not either. So definitely that. And I think also really focusing on what her life must be like outside of this and how this has shifted her life and the way that she views herself and her family as well.
Fantastic. Yes, absolutely. So we are going to go ahead and get started. Steve is going to put some time on the clock. Susie, the witness is yours.
Thank you. Thank you, Your Honor.
You're welcome.
Good morning, Ms. Maddison.
Good morning.
May I call you Ms. Maddison?
Yes.
So, Ms. Maddison, my name is Susie Injijian, and I represent Gustavo Lopez and his family in this case. You understand that?
Yes.
And we're going to talk a little bit about some of the testimony that we just heard you give on direct examination, okay?
Great.
So, you were on your way to Redwood Commons Shopping Center.
Yes.
You were going to do some shopping?
Yes.
And you'd been to Redwood Commons before.
Yes.
In fact, you've been there many times before, right?
Yes, I have.
And you'd been to that shopping center in the late afternoon.
Yes.
So you're driving your Honda Civic hatchback down Cypress Avenue.
Yes.
You're driving towards the sun.
Yes.
And the shopping mall parking entrance is over to your right.
Correct.
And you had entered through this entrance before, right?
Yes.
And you've made a right turn into this entrance before.
Yes.
Many times, in fact.
Yes.
And as you're going down Cypress Avenue, the sun is in your eyes.
Yes.
That's what you testified to.
Yes.
And your vision is impaired.
A little, yes.
And you know, as you're going down Cypress, that at this particular vehicle entrance, there's pedestrians sometimes cross.
Yes.
Maybe you'd crossed that vehicle entrance yourself on foot at some point before.
Yes.
And you knew on the day of this incident, as you're going down Cypress Avenue, that the sun was in your eyes as you were making this right turn.
Yes.
You didn't stop your vehicle before turning right, did you?
No.
In fact, you were turning into the pedestrian crossing at 10 to 15 miles per hour.
Yes.
We know, of course, what happened then. Right?
Yes.
There was a thud at the right front of your car.
Yes.
You felt it.
Yeah, I did.
And you heard it.
Yes.
It startled you.
Yes.
You saw the body of Gustavo Lopez become airborne.
Yes.
You saw his body impact your windshield.
Yes, I did.
And the hood of your car.
Yes.
And you saw his body flung to the ground.
Yes, I did.
And as your car was moving, you actually felt the right front tire roll up and over something hard. Do you remember that?
Yes, I do. Sorry,
Your car jerked up and down. I'm sorry, I cut you off. What were you saying?
It's just difficult to talk about.
Yeah, I understand. But for purposes of the case, we need to get your facts for the jury. Your car jerked up and down, right?
Yes. Yes.
Like you'd hit a rock or something.
Yes.
Turns out that was Mr. Lopez's dog.
Yes, it was.
You would run over Mr. Lopez's dog.
Yes.
So you stopped your car.
Yes.
You got out.
Yes.
You saw Mr. Lopez on the ground.
Yes.
He had a gash on his forehead.
Yes.
He was holding his dog Tonky in his arms.
Yes.
The dog wasn't moving.
No.
But it was making some sounds.
Yes.
And you saw blood on the dog's fur.
Yes, I did.
So let's go to when the paramedics came. You saw the paramedics arrive?
Yes.
And they began tending to Mr. Lopez's forehead, to the gash there?
Yes, I believe so.
And Mr. Lopez continued to cradle his dog?
Yes.
You testified that you heard Mr. Lopez say that he didn't need an ambulance?
Yes.
That's what you heard him say?
Yes.
And you heard him say something like, I'm okay, or something like that?
Yes.
And Mr. Lopez stayed at the scene?
Yes.
Until his family came?
Yes.
And then the family came and took Mr. Lopez and Tonky away from the scene?
Yes.
Now, you heard Mr. Lopez's testimony in this trial?
Yes, I did.
He's testified that he experienced disabilities since he was struck on that day.
Yes, that's what he said.
He testified that on the day he was struck at Redwood Commons, his family took him to the ER, to the emergency room.
That's what he said, yes.
And he testified over the care he received over the subsequent months.
Yes.
Up until today.
Yes.
And he's seen orthopedists.
Yes.
Chiropractor.
Yes.
Pain management.
Yes.
He's been diagnosed with bulging discs in his neck and in his lower back.
Yes, that's what he said.
And he testified that he was offered a spinal fusion.
Yes.
And a surgery to repair his rotator cuff in his shoulder.
Yes.
And he had a severe sprain in his knee as well. Do you remember that?
I remember him saying that, yes.
And you know that Mr. Lopez is a carpenter, right?
Yes.
That he used to work 50-hour weeks before he was injured in this collision.
That's what he said, yes.
And he's testified that now he has to turn down jobs because his strength and abilities haven't been restored.
That's what he said, yes.
And you also heard Mr. Lopez talk about cognitive impairments that he's experienced. Do you remember that?
Yes, I remember him saying that.
He can't remember things that he knows.
That's what he said, yes.
Like he's blanked on his own phone number.
That's what he said.
And we heard from his family that he's had these unpredictable changes in mood.
Yes.
He gets irritable over little things.
Yes.
Now, you personally, just you, not your attorneys or the experts your attorneys have hired, you personally do not have any evidence to contradict anything Mr. Lopez has said about his health since this accident. True?
That's correct. I'm not a doctor, so.
And obviously, you haven't been to any of his medical appointments.
No.
In fact, except for seeing him at this trial, you've not seen him at all since the collision. True?
That is correct.
Going back to the scene, at some point at the scene, you called your dad or texted him?
Yeah, I called him.
And you called him because, well, something bad had happened.
Yeah, he's the first person I call.
And you needed his help
Yes.
because you'd hit a person.
Yes.
And you'd hit the person's dog.
Yes.
And the impact had been hard enough to damage the windshield and hood of your Honda.
Correct.
So your dad is a pastor, isn't he?
Yes, he is.
At one of the largest congregations in Bakersfield?
Yes.
You are active in your dad's church as well, right?
Yeah, very much so.
You teach kindergarten there?
Yes.
So you think a lot of your dad?
Yeah, I do. He's the best man I know.
And he must think a lot of you.
I hope so.
So when your father arrived at the scene, the paramedics were still there?
Yes.
And Mr. Lopez was still there?
Yes.
And you saw your father speak with the police officers?
Yes.
He talked to them for about half an hour to 45 minutes?
I can't tell you exactly how long it was, but he talked to them for a little bit, yes.
And you didn't see him ever approach Mr. Lopez, did you?
No.
You didn't ask him to speak to Mr. Lopez?
No.
And then you and your family left the scene together?
Yes.
Ms. Maddison, you've accepted responsibility for this collision, true?
Yes, and I'm very, very sorry that it happened.
I'm sure you are, and you know that it's the right thing to accept responsibility for this collision.
Yes.
And this collision happened on September 23rd, 2023?
Yes.
2.5 years ago.
Yes.
And you decided to admit fault only 2 days before this trial began. Isn't that right?
Yes.
Before that, you denied any responsibility for this accident.
Yes.
And now that we have a jury, you accept that this accident and the damages caused were all your fault. True?
Yes, within the last couple of days, yes.
Thank you. That's all I have. I don't know know if I went long enough. Did I go long enough?
That was perfect. It was like just 14 minutes.
Oh,
Oh dear. I don't think you could go any longer. It would be a murder, and then we'd have another case on our hand because of the murder that you caused to this poor witness.
You got a lot accomplished in 14 minutes. That was a little bit
Holy
of
cow.
everything. Wow. How did that feel, though, to you? We'll go to you first, Susie. Did you accomplish what you wanted to accomplish?
Well, I did, but what was scaring me was, oh, she's angelic and sympathetic, and the jury's going to be feeling sorry for her. And so I had to show her, that I respected her humanity, that I think she's a good person, and her dad's a good person, and they love each other very much. I wanted to get that in there to humanize myself. I think if I did it again, I might have, I don't know. This is tough because, there are lawyers who would be, more, I don't know. I guess, let me think about this a minute.
Mm-hmm.
I've heard lawyers talk about the witness gets up and he looks like my teenage son. And I was all ready to get him to admit all this stuff. But then that's not what I ended up doing because I didn't think it was going to help me. But even before I knew what kind of a witness Sara would be, whether she would be a crying witness or or a real docile witness as she was, I decided that I was going to focus on humanizing Mr. Lopez as much as possible. And the best way to do that was to really talk about his dog.
Yes.
Because people understand the love of a dog. And that just puts us all on the same level. We see past ethnicity and demographics when we see a person holding his dog, his bleeding dog. So that's the approach that I took.
Yeah. Did you have any expectation that she might be something other than angelic? What potentially is on the page? Like, did you have any suspicion that she might be other than that?
Well, she could have been really sort of assertive and defensive. She could have betrayed maybe some bias against Mr. Lopez, that he's not a member of their church and therefore he is not going to heaven. Sometimes you will get somebody like that who betrays that a little bit. But kindergarten teacher, I was actually expecting her to be as she did portray herself, just really likable, really cute, really remorseful, and not, and following her lawyer's advice, not to get defensive, not to argue with me.
Yes.
Which is what her lawyer would have told her to do.
Here's what I noticed, though, that you did do, and I don't know if this was purposeful or not, but I could, in your first few questions, I did notice what I would say in the acting world was your intention was to dip your toe in the water to see how is this witness going to react and how do I adjust? And I noticed you take that approach with your first couple of questions. And what I saw then in that case, that it buys you a little bit of time, gives you a moment for both of you even, because she's never been on the stand, to acclimate to whatever water you are stepping into. And that's what I saw. I don't know if it was purposeful in that way, but that's what I could see you doing to kind of have this moment of adjustment for yourself to do that. Is that something that you intended or just something that I saw, Susie?
I don't know. It might have been unconscious. I certainly was sizing her up. I wanted to get an answer from her so that I could see where, basically, what is her tone? Mm-hmm. What is her approach going to be in this?
Yes.
So, yeah, but that doesn't mean that I knew where she was going to go. There were several times where I thought she might start crying, and I'm going to have to do something about that.
Into the crying part, because I saw there was real emotion there, and Sara did a great job with that. And I can't wait to get your thoughts on that. But for me, what I was seeing is because of the tone that you held, it was tough for her to cry because you were so smooth and you weren't attacking. There was no attacking in your tone. It was just so factual that even when and I'd love to I want to kick it to Sara next, but it seemed like even when you went by that step by step, when you were painting the picture so effectively about the scene of the accident, and then you went back again, it was hard for her to, because I don't think she was being attacked. So it's hard to get to that crying place if you're not, if somebody's not going after you and accusing you. And, there was sometimes when we're playing these parts, tears can help us escape somewhere that's uncomfortable and where we don't want to be. But I think you kept it just uncomfortable enough and comfortable enough to where she couldn't go to that place. But Sara, what did you feel? How did you feel about the cross?
It was wild. I think that's the perfect way to describe it, Steve. I feel like I was way more comfortable than I was expecting to be. And Susie, the way that you spoke to me was so kind that I was like, okay, I just have to listen to her and answer her questions, and I can get through this, and then it'll be done. And that was very much what I was feeling. And there wasn't really anything that you were giving me that I felt like I had the right to fight you on.
I'm so glad that you said that, because that's what we tell attorneys all the time and what we work with our clients on. When you are doing it fact by fact like that takes so much of the fear off of us that it does put us at ease. And so that is to your advantage, Susie, and any attorney's advantage, to really take it factually, take all of the conclusions out of it and do it step by step. That's another thing where if things are so step by step like you did it, Susie, even starting off with the fact that she's done this before, she's gone down that street before, she's made a right turn there before. All of those things, fact by fact, doesn't also allow your witness to feel like, oh gosh, I got to fill in a gap, because you were doing it so incrementally that you were missing nothing in each of your questions. So that also, doing it that way also takes a load off of us to feel like, oh my gosh, she's missing something. I got to say something more than a yes or no. So I loved that chapter, by the way, all the things that she has done before, making this a normal situation. Like, you know what I mean? Like she would have known, she's done this many times before, and not being afraid to say, the sun was in your eyes. Like that, for me, your vision was impaired. From my opinion, I don't know that every attorney would own that and take that on. Steve's shaking his head too. I think that takes a lot of courage and to take that angle.
Well, and she gave you like a great answer for you, because she said a little. And I was like, oh, is she going to loop that? Is she going to hammer her with that? And you're like, no, that's good. I'm just going to move on.
Yeah.
So Susie, was that a moment where you were considering what to do with that answer, or did that just where were you with that?
So I actually assumed that that was her defense, that the sun was in her eyes. So I thought that was a given. And so when I asked her, I really thought I was going over old ground and didn't think I was, grabbing a new admission. And I didn't think to loop it at all, because I thought it was already part of the record.
Yeah, I guess it's the idea of you owning her story by saying it and confirming it, confirming the fact that the sun was in her eyes. I guess that's how I felt, like that. I don't know that every attorney would put that as far as owning it in that way. Does that make sense?
Yeah, I will add that in an admitted liability case, I don't know that a judge would have allowed those questions. It's a fine line. You are not allowed to ask about what they did wrong or what they failed to do, and I did go there with her. I did expose things in terms of the right turn lane. She didn't stop first, and then she was 10 to 15 miles an hour. I think there would have been objections, and I would have argued that, well, I am allowed to set the scene And so it would have depended on what the judge wanted to do with that and how much the judge wanted me to be able to say about the scene. But we can certainly talk about the scene in order to establish damages and what she saw and what happened after the collision and all of that. But that particular piece with the collision, the sun in her eyes, I don't even know if I would have been allowed to say that.
I like that you're not afraid to go there, though. And, it's that whole thing of it's better to be forgiven than to ask permission. Is that with that kind of an ethos, is that what you bring to any cross-examination when you're in trial? Or is it, you have to be really calculating because there might be some danger in that?
Oh, I think some lawyers push the envelope way more than I do. I don't like objections. And so I'm not going to, because it just interrupts the flow and it interrupts the story that I'm eliciting. But some lawyers, they'll just bulldoze beyond the judge sustaining objections, and they're comfortable doing that. Me, if there had been an objection sustained, I would have pivoted and been happy that the question got out there, because then the jury heard it and they know.
To add something about the sun fact,
yeah,
I think that was part of what made me comfortable as well, because I was like, oh, she sees me. She's not trying to accuse me of using my phone. So for you to confirm my story and something that was part of my defense was actually really successful in getting me on your side, I think, because that made me more comfortable, because you were agreeing with what I said happened in that way.
I want to go to the next part of the cross where we get in. We kind of talked about it already, about setting that moment of the impact. But what you did was it ignited all the senses so much. It was, we could feel it. We could hear it. There was so much. And then there was like the bump, like you hit like you rolled over a rock. And then we find out that's the dog, that's, you took her step by step through that, and we could all see and feel that. Before I get your feedback into it, Susie, Sara, how did that feel as the witness?
Yeah, it was horrible. From an acting perspective, it was great because I didn't have to do any work because it was all being relayed to me. And as an actor, that's obviously something that I had thought about, but it was completely laid out for me in every sense. There was no way for me as the witness to not relive exactly what happened. And even that detail, like you said, of like going over a rock, that must have been exactly what it felt like. And then to realize that the rock that you went over was actually a dog is horrifying. Yeah, it was laid out. There were no gaps.
Yeah.
It was so specific.
Your word choice, thud, is just one of those words that like you say, but it's also like, I don't know, is it automatopoeia? Is that the right way of saying it?
Mm-hmm.
It sounds like it. Yeah.
Yeah,
body became airborne. Like, how is she going to deny that? Of course she freaking saw that, right? But that is also when you could see her kind of go internal and feel, I could see, at least from you, Sara, like starting to get emotional because you were walking her through it. But again, so fact-based, flung and blood on the dog's fur. Just images that we can see, hear, and then to reduce the dog to a rock. I just thought was really that the word choice of rock was really important. Yeah.
I want to say something about the dog questions, because we've already talked about it, how that's such a great part of, and I don't mean great because it's awful what happens to the dog, but that was such an impactful moment. And, going back to, people, like you said, Susie, people care about animals more than humans half the time. And so you really use that. And we've worked with cases where there was reluctance to talk about the dog, or a dog involved in whatever the accident was.
But in this particular case, because this is based on a real case, right, Steve, that we've kind of altered a little bit, and there was a dog involved.
Yeah. And there was a reluctance to talk about it because you can't, it's not part of the injuries that were sustained. And so it's like, well, we can't go after that, but I'm like, it's not about the injuries. It's about igniting the jury's, their anger about this. They're getting them sucked into this story. Is there any danger to that, Susie, as someone who is not a lawyer and we just think about story elements? Is there any danger to bringing that dog in there? Are you worried about there being some kind of objections or anything to that dog?
Well, only if the dog is really unrelated to what's going on, which is hard to imagine. I mean, if you're walking your dog and you're hit and you're stunned, you're going to think about your child and whether they're okay. And so I sort of added that. I embellished that fact that he was actually cradling Tonki. And that allowed me to explain why he waved off the ambulance and said, I'm okay, because all he could think about was his dog. I mean, and I think everyone can relate to that. So that was the narrative I was going with. If he had been walking, I don't know. I can't imagine a scenario where he wouldn't care about the dog. I mean, even if it's somebody else's dog, it's like the responsibility you feel it's somebody else's child. I mean, really, our dogs are our children. So that to me was a real gift in this fact pattern against the defendant. However cute she is, she ran over a dog.
You also went into the play-by-play of the medical and, assuming that she was there in the courtroom while your client was testifying, I don't see any other way, and I want to ask you, Sara, that she denies that because she could potentially come off as insensitive, denying any of those claims that she heard him testify to in court. Sara, how did you feel during that section?
I think I got a little uncomfortable toward the end just because there was so much. And it didn't feel like there wasn't anything I could add or say to any of that other than agree that that's what he said. Because as Susie said, I wasn't in all of those doctor's appointments. So I was toward the end just getting a little, okay, what's the point here on my end? Because to her, I think it feels a little irrelevant to go over each of those injuries because she can't say anything to that.
And that's a good point because, I was taking a risk that I might anger the jury. The jury might resent that I'm taking her through all that because she doesn't know. And it's unfair. But it was an opportunity to get those facts out there through the name defendant. And so that the jury understands what I'm trying to tell the jury is she doesn't personally doubt any of this is true. It's her lawyer and these experts, paid experts that they brought in, they paraded in to undermine the claims of the plaintiff. But she did really well in making sure the jury knew that she's not agreeing that those are his damages, but she's agreeing that that's what he said in this courtroom. Yeah, she heard that. He testified to that. So she held her own.
I was going to say that strategy of taking the focus off of Hannah, Sarah's character, Hannah, and putting it on the lawyers. We actually are working on with an attorney on a case where there is a sympathetic defendant, and that was what we talked about. Let's put the focus on this big law firm, and you can just kind of, hey, this defendant, you can see, doesn't have a whole lot of money. It's this big law firm. Well, how does the big law firm come to be? You can add that together. That's a whole different thing. But really putting the focus on the attorneys. Do you try to do that often? Unless it's egregious, the defendant is worthy of that. But do you try to put the focus on the attorneys and the experts as much as possible, Susie?
Actually not. I try to ignore the attorneys and act like they don't matter. They're irrelevant. I don't let them trigger me. And I notice that they like to pile on me and they like to complain about me to the jury. And I don't think the jury likes that. So what I did here was, because she is so likable and because she's a Christian, she and her father are very active in a church, love thy neighbor. And I want the jury to know that that's who she is. And she's going to agree with me that Lopez is entitled to be compensated for what happened to him, and quite apart from what her lawyers are saying. So it was really not, it really wasn't demonizing the defense team as much as it was making them irrelevant, getting them out of the way so that the jury will understand the human a decision they need to make here between human beings. Here's this nice girl. She made a mistake. She regrets it. And here's this nice man who's going to live the rest of his life with these damages. And, he needs to be compensated, and she wouldn't disagree.
I think the one part, and we're, going to that last part where, once again, no attacking tone, you were consistent all the way through. But when you bring up that, and she has to own it, because, even though it was likely not her decision to do this, but to say that you only accepted responsibility 2 days ago, it's like, what do you say to that? It's such a, those facts are harsh. And for me, I was like, oh, here comes the finishing touch. Like, what a way to finish that cross by going into that whole scenario. That, for me, I was just like, oh, devastating.
Would you have ended there, Susie, in a trial as well? Like, if you potentially had more time, even outside of this, your 15 minutes, is that a good place that you might have ended anyways?
Well, the shorter the better. And with this witness, I got everything that I needed, and I don't want her on the stand too long because she's so nice.
Yeah.
But a lot of times with admissions of fault, they get, they stipulate that you can't mention that it was only 2 days ago. So the defendants have done away with that because it is very effective. But maybe they don't do that all the time. I know that in the trials that I've been in, the judge tells us you can't tell them. You can't let the jury know.
If that was the case in this cross, is there another way that you would have tried to not bring that up, but is there a different way that you would strategically try to finish this cross to kind of maybe not get that same effect, like exactly that same effect, but try to finish on that like nail in the coffin kind of way, like you were able to in this simulation?
Well, I think I wouldn't have talked about how it's 2.5 years later. I wouldn't have talked about time, but I would have said to her, you admit fault and you acknowledge that is the right thing to do. And I might have, had a few more questions about that, about what is the right thing to do. When you cause harm, you understand that under the law, that harm needs to be compensated. Mm-hmm. And that it's the jury's role to determine what that compensation is. You understand that? I mean, something like that. So I would still make sure, I would still ask her, you admit this was your fault. Assuming I'm allowed to, and I think I would be, you just can't say when. In a lot of courts with a lot of judges.
I want to go back because you actually did something right at the end. We were just talking about painting the picture of these, love thy neighbor people. And before you closed, you brought her dad into the scene of the accident and going through that. And when he arrived, making sure to go over to Hannah, and that her dad, a pastor, a well-known pastor, did not go over to make sure Mr. Lopez was okay. Mm-hmm. That was such a huge admission, but just another picture in our head of these people and their self-preservation versus making sure that somebody who is hurt, dog or human, are okay. How did that feel, Sara, to you? I want to go to you first. How did that feel kind of going through that particular portion?
Yeah, I think more than anything, I think I was thinking about, I think Hannah was worried that her dad would become this figure to be used in my story that would go against me. And so I think I was trying to really be like, okay, he wasn't involved. And I think I didn't even realize in the moment until after that fact pattern that that's what that would mean. Like, I was so in it that I was like, oh yeah. No, I didn't ask him to go over. And then I was like, oh, well, yeah. Yep. That's not great.
Yeah.
It so makes sense for this character who feels extreme guilt about so many things. And then I love that you went, really took an emphasis on that relationship between her and her father and trying to protect him and his name. And then it leads to kind of like a bad picture. But that's, once again, Susie, you were delivering these questions without any extra vigor, or it was just consistent. And I think that's what allows you to get away with so much stuff. And we try to teach that all the time. It's just like detaching from the emotions of it a little bit when you're the lawyer delivering these cross-examinations, and realize that you're doing so much damage without needing to get angry and without needing to get fired up. So, I mean, we know that's your delivery, Susie, but what do you think about that as far as like not getting into those like fired up, angry emotions when you're going through a cross like this, or any cross?
So I think, I learned this from you, and I even said it on the webinar last Friday, was about when you are going to approach a witness, you set an intention about what feeling you want the jury to have by the time you sit down from after your examination. And so I didn't want the jury to feel like I was beating up on this nice girl. And I wanted the jury to feel that I am bringing out the facts. And they may be tough facts for her to own, but I'm going to acknowledge her humanity and separate that, not personalize them, not blame her for these facts. These facts have happened, and we can all agree that they happened, and this is how they happened. But I did, for example, shift my tone when I said, you think a lot of your dad, don't you? Like, I'm a daughter too, and I know what it's like to feel, really good about a good dad. And he loves you too. And she says, I hope so, because she's feeling terrible about herself. But there is a moment of, I get it, and the jury sees that I get it, that, she's a loving daughter and she's a loved daughter. And that's a good thing. And then we move right into, and then you guys are circling the wagons, right? And nobody notices that, except that that's the fact, the pastor didn't go up to the injured man to say, are you okay?
I want to ask you, and this was not a question that we had prepped you for, but I know that you've done this before because we talked about it in the case that you did with the electrician, to get that word choice of how they're going to potentially frame your client, how the defense is going to frame your client. You kind of took a step back, right, Susie, to kind of think about it in that way to ultimately help you come up with the word choice that you used that would boost your client. Can you talk about that process a little bit?
Well, it's a very high-tech process these days because we do big data studies and we get word clouds. So word clouds are little collages of words, and they are color-coded according to whether these words were spoken by favorable jurors and jurors who were unfavorable to your case. So it's red if they're more pro-defense, and it's blue if they're more pro-plaintiff, and it's black if you hear this, equally from both sides. And then the more frequently you hear the word, the bigger it is. And the less frequently you hear the word, of course, the smaller it is. And so there's a word cloud for every witness, including the plaintiff. And for example, in the case that we did, hardworking was huge. And it was mostly blue, but it came from both sides. And so we select words from those word clouds based upon this research that we do. And so it is pretty sophisticated. We focus everything.
It's come a long way since you first started trying cases so many years ago. It's got to be amazing, the tools that are available now versus when you first started as a brand new lawyer.
Yeah, but then we are still reliant on our own imagination and ingenuity, because by the time the evidence is all out there and you're going into closing, most people don't have the opportunity to do a focus group or to do big data. And so you've got to read your own jury, and you've got to read the evidence that came out and use themes that are going to resonate the most in your closing argument. So, it's not all taken over by tech.
Yeah, I remember you had to do that because weren't two witnesses at the last minute, at least two, kind of thrown at you? How did you, and there's no, you just got to do it. There's no AI even quickly to help you do that. So what were some of those things that you pulled in to help you on the spot kind of create those crosses? And by the way, kill them both, those experts.
Yeah, they were both defense witnesses, and I'd never met them before. I'd never taken their depositions before, and they were very high risk witnesses. But I would say that the thing that was the saving grace for me was knowing the case so well and knowing what the defense was going to use these witnesses to prove, so that I knew what they were not prepared to testify about. And then when I asked them questions about what they weren't prepared to testify about, I got honest answers that I expected to get, because I knew the industry so well. I knew the particular what my client had been doing as an electrician. So one of them was an electrician. So I asked him, well, what does your employer require you to do under these circumstances? And I got exactly the answers that we had been saying all along our client did. And in doing so, met or exceeded the standard of care. So that we got gold from that guy. And it ended up being something we used prominently in our closing argument. And the other one was just so poorly prepared and he was so flip that one was a lot easier to do. But just being prepared, I prepare to help me cope with the anxiety and the stress of getting up on game day. So I over prepare, and you can't get away with doing trials without preparing. But the greatest benefit to preparing is having that mental agility and the ability to deal with the unexpected as it's being thrown at you.
With that being said, I do want to go back to what we were talking about as far as the closing argument. So when you're approaching that closing argument and you have a case like this where the defendant is extremely sympathetic, how do you go about asking the jury to assign significant damages? What are some of the strategies that you would use going into that closing argument where it's really important? I mean, the whole purpose is to get an award that provides for your client, that really, really provides for them, not just getting against the defendant, but really getting that life-changing award, that verdict awards. What are some of the things that you try to do to make that happen?
So with a very sympathetic defendant like Hannah Maddison, I'm going to definitely let the jury know that there is, we're not blaming her personally for this. This is, this is a damages trial. And in fact, I don't have to prove that she's liable because she's admitted it. In fact, in some ways, it would be harder if they had denied liability, because then I would still have to make the jury point the finger at her. So it's easier to do it here when it's, admitted liability. We're just going to focus on the damages, and this has nothing to do with Hannah Maddison personally. She's a lovely person, but it is what it is, and you have to evaluate damages. That's one thing I would do. And then the other thing I would do is go back to what we've clearly talked about in jury selection, if not me, then the defense, which is you can't make your decisions based on sympathy, right? Sympathy for the plaintiff. And I would say, and you can't base your decisions based on sympathy for anybody, either party, the defendant, the plaintiff, or the defendant. And she's very sympathetic, and I would take that head on. And then just tell them, it's the same rule applies on both sides. And then really spend a lot of time on damages and as little time as possible on her. That's
great. I do want to switch it to Sara really quick. You had such great insights as far as your journey through that cross, and I really appreciate that. And I appreciate the preparation that you did. And with that in mind, one of the things that we always do when we're working with our clients and we're approaching a deposition or cross is we do a basically a character study. When you're taking on a role, and I think this could be helpful to the people who are listening to this as trial lawyers, when you're taking on a role, what are the first things that you do to study that character, to really try to understand that character from beyond the words on the page?
What a great question. I think a lot about what their life is like and how I can relate to it, and maybe what's different from myself or what's similar to other people that I know. I think looking beyond the page to who they are, what their personality is like. You can't really tell what someone's personality is like by reading words that they've said or necessarily a description about them. So I think looking at that and thinking about what's important to them, who's important in their life, what are the important things in their life, what are their touchstones, how do they live their life, really going into those details, I think, can very quickly make someone more human and more alive. And those are the specifics that really make a person and not just a description or words on a page.
I'm thinking of like texting, even like, just writing a text and it's like, oh gosh, I hope that comes off okay, because it's just, you don't know context or how somebody's actually saying something. If, it could sound angry to you in a text, but that's not really maybe how it might come off if they were to literally say it. And then knowing like some attorneys can, get away with different things than others. It just depends. You can't base it off of, what you read on a page.
Absolutely. And I think also thinking specifically with Hannah, thinking about how she would react to different types of people, because that's the unknown here, right? It's just like being in a scene. You can have a goal and have what you want to get across and what you want to say, but you might not get to do that. And it might be separate or different from what you were expecting because you don't know who the lawyer is or how they're going to treat you or what angle they're going to take. So both as the actor and the witness, it's like you have to be agile to whatever you receive from the other end.
I think a really important thing that you said about when you're thinking about this character is what's important to them. And I think when we're thinking about, and we're looking into, an upcoming witness that is going to be deposed or cross-examined by one of our clients, I think that's one of the things that we always think about is what's important to them, because it can tell you so much about what they're going to say when we're trying to, take on that witness. Like, how would they react? What are they going to say? And, one of the things that I think it showed in this particular cross was your the devotion and, the way that you look at your father and him as somebody that's prominent in the community. I could really tell. And it showed it came out there were, you know, they had that moment where we talked about it, and it came out so naturally how that worked out. But I think that's such an important thing, is to take an empathetic look at who you're going to cross or depose. And I want to bring it to Susie and really quick, and I know we're getting towards the end, but Susie, when you're thinking about that witness or that you're going to depose or you're going to cross, do you take that same approach of thinking about what's important to them and how that might get them to react?
Well, you know, I like that particular phrasing. I think what I think about are what is their interest here, and what are they going to want me to elicit and what are they going to want to conceal? And so I look at their motives, and then come up, you know, with a cross based upon my needs for the case. I think in this case, I really appreciated that Sara did, you know, thought about Hannah and what kind of person, how Hannah lives her life, what her life is like, you know, going to the mall, teaching kindergarten, you know, remaining really close to her family, the family that she grew up in, you know, this Christian household that has some celebrity status in the neighborhood. So she actually likes that. She didn't rebel against it. She didn't leave it. And so those facts communicated the same thing to me, that that's who I'm dealing with. And she's also a good girl. She's going to do what she's been told to do. And that is not argue with me and be sort of an easy witness and just get through it. I liked when she said that, you know, that was her mindset as Hannah was, I just have to listen and answer the questions and it'll be over soon. Yeah. And so that made her, you know, that made my approach a good one for her. So if she had said, no, that's not true. My dad did go and talk to Mr. Lopez, for example. I can't say in a vacuum now what I would have done, but if we were to rewind and she had done that, I might have, you know, looped what she said. Because the particular words she chose might have been revealing of something, and I could have gone someplace with that. But no, it's frankly much more realistic that the pastor didn't go and talk to the.
I wonder if it would play into like you in terms of damages, like he went over to make sure he was okay. And you want to make sure he's okay, or what, you know, however it would actually be able to do it in court, that you want to make sure that he, you know, remains okay.
I would not have taken that risk unless I knew that there was established evidence that he did not go up there. Now, if I knew that he had gone up there and asked Mr. Lopez how he was, I don't know that I would have touched it. If there was some other aspect to that conversation that I felt I wanted the jury to hear, maybe I would have, but I was secure that it's in the record. You know, let's say the pastor testified and he, you know, he testified only to conversations with the police and his daughter, and then he left. Then it would have been beautiful to bring it up, because then nobody had asked him before, well, did you talk to Mr. Lopez? And I could have done it through his daughter.
Well, Susie, any other takeaways from today if you had to cross this witness tomorrow?
Well, I would have been, I was definitely tuned in to see if she's going to start crying. And because then you do need to deal with that. And the way you deal with it is to remove her from the scene and get her to focus on other facts. So I might have jumped around with my chapters. So if she started crying at the point where she hit the dog, I would have jumped to, you know, something else about, you know, her dad, the pastor, or something like that. But I didn't have to do that. She was on the verge of tears, but I was able to continue with the chronology that I wanted to follow, and it was okay.
Yeah, I think it was because you were going so fact-based. You didn't kind of let her sit in any of those too long. You kept your pace, and something that even as a crying witness that we've played, you know, we can definitely milk it, but it's because, you know, like I feel like it's because the attorney's really trying to draw it out in us, but you just kept going on what you needed to do and weren't fazed by that in that respect. Yeah. Sara, you're an artist who doesn't necessarily work in the legal field, but you've been with us a few times now. What stood out to you today?
I think really just thinking about, and I touched on it a little bit at the end of the last thing that I said, but thinking about how cross-examining someone is not a singular experience. You can't decide or figure out exactly how it's going to go, even if you've planned it. And I think that's where a lawyer's experience and an actor's experience really overlap, because you can have a goal going into a scene or as a character, and you truly might not get what you want. Most of the times you might not. And I think that's kind of what's fun to me about being an actor, is you don't know what's on the other side. You don't know how you're going to come out of it. You have this other person to play with, and something comes out of it and you don't know what it's going to be.
I think that attitude is such a great way to look at even cross-examination and depositions, that there's something exciting there, that it's not necessarily like this, or, oh God, I hope it goes exactly the way I want it, but having some excitement about there's some unexpected stuff that's going to happen. But if I'm dialed in and I'm prepared for things to not go the way I want them to, and especially if you have the skill set and the tools to deal with that, gosh, it could be an amazing experience, or a much more positive going into it, a much more positive experience. Susie, I know you have all the tools. So is that kind of how you feel about going into those depositions and crosses like that?
Yeah, I mean, there's so much preparation and really scripting, because you're designing your examination, but the unexpected, you have to expect the unexpected. And I love Olivia's story about the scene where the potted plant lands in the actor's hands, and he reacts by handing it over to the woman that he's wooing, because he just like made it a part of the scene. I just love that story, and it's really emblematic of what we do.
Yes. And you can find that in our Acting for Trial Lawyers 100 on-demand course on our website, because that's part of it. It's how do you deal with something that's scripted, but still stay nimble about it, still adjust to your audience or your witness. And that's what we study. That's what we do in the theater. So it kind of is that balance, that delicate balance. Steve, should we do our 3 favorite things today?
I'll tell you, one of my favorite things was cradling the dog in his arms. Oh my goodness.
You took mine. I had cradling Tonky. I added the word, just a name Tonky. You have to say that.
I'm very proud of the names. It was like Hannah Maddison is like a double, like who she is. But yeah, Tonky. When I saw that name, that's a common Guatemalan name for a dog, I was like, oh.
Steve did his research. Look at that.
I did.
The image in of the pastor not going over to make sure that one of the people in his community was okay.
And it felt like a rock. It felt like you were rolling over a rock. My goodness, that was so strong. That was such a strong leading question right there. I'm
gonna add a 4th thing real quick.
Sara's
cross. She wore a cross today. If you're just listening to this, I just in complete character today. That's one of my favorite things.
Yes, absolutely. So Susie, where can people find you, and can people book you to speak at events?
Well, I've spoken at events. Yeah, I'm a very low-key attorney. I've been around for a long time, but I've done some big cases, including a Supreme Court victory, U.S. Supreme Court victory in an aviation case. I am in Berkeley, California, and if you have the spelling of my name, you can find me online. So
we are going to link it too as well, so people can find you. Sara, how about you? How can we keep up on what you're up to?
Yeah, if anyone is in the LA area in June, I am performing at the Hollywood Fringe Festival in my friend's show. It's called All Cats Go to Hell. Not sure how Hannah Maddison would feel about that. But it's about a group of kids who accidentally blow up their neighbor's cat, which would be an interesting case. So that's kind of fun. And I am on Instagram, Sara.Taylor13.
Fantastic.
Posting my antics.
Yes, we will definitely connect into the show notes here. Well, if you are enjoying what we're cooking up on our podcast, make sure to follow us. Tell your colleagues about everything going on here in the Cross Lab.
And if you like what you're seeing, please follow us and get all your friends to follow us, all your colleagues, and give us a 5-star review. Those things really help us get the word out. We think that what we're doing here is really important to make you a better advocate for your clients. So don't be afraid to get the word out.
Yes, Sara and Susie, thank you so much for joining us. Thank you, Sara, for your insight into storytelling and into Hannah Maddison, and Susie, badass attorney. We so appreciate your time. Your clients are so lucky to have you. Thank you for joining us both.
Thank you.
Yeah. And we hope you take the best of today with you to court.
Well, that's the end of our experiment. So we'll see you next time on Cross Lab.
Please like and subscribe to Cross Lab wherever you get your podcasts or webcasts. If you really liked this podcast, please write a review. If you didn't, this podcast has been Paul Hollywood's Baker's Podcast. Thank you for listening to Cross Lab, a Trial House Consulting production powered by Law Pods. To get free resources for your next trial, go to houseimprov.com, HAUS improv.com. This program is written and produced by Steve Hohman and Olivia Espinosa and edited by Mark Crespo.
The discussions and content presented in this podcast are for educational and informational purposes only. They are not a substitute for professional legal advice, guidance, or representation. Participation in this podcast, including cross-examinations and feedback, takes place in a simulated training environment with fictional witnesses and scenarios. Any resemblance to real persons, cases, or events is purely coincidental. The views expressed by the host and guests are their own and do not necessarily reflect the opinions of any organization or entities they may be affiliated with. House Team Productions and Law Pods are not responsible for the accuracy, outcomes, or application of any content or strategies discussed during the podcast. If you have any specific legal questions or concerns, we encourage you to consult with a licensed attorney in your jurisdiction.